keep saying the same thing over and over. The facts that Commissioner Carringer, I think, wanted answered. The facts were that the state investigated the allegation of child abuse. They said there was nothing substantive to that allegation. When you have an allegation that is brought for child abuse, the statute says you shall turn it over to DCS. Whether it's real or whether it's Memorex, it doesn't matter. You turn it over to DCS. So then an investigation starts. The state does that on their own. The county's out of it, the school's out of it, the law director's out of it, everybody's out of it. The state of Tennessee has it. The state of Tennessee comes back. They will not give you the details. They will not tell you what they have. They will not release the reports. There's a child involved. But in so doing, they sent the message to say there's nothing substantive here because, number one, there is no indictment. Number two, during this time that they were alleged, your license as a teacher is suspended, or if you're working with children, you're suspended from that activity. The State Board of Education then reinstated those licenses based upon the investigation of the state, not Knox County. The licenses were reinstated, and under all of the allegations related to that child, they made a decision that she could go back to work. Now, the statement, there must be something to it because the law director settled the case. I made the statement that the law was in my favor. The facts are in my favor. The witnesses, however, involved a special child. I didn't think it was in the best interest of Knox County or that child to go forward and hire the experts I would have to hire and do what it would take to get the law in my favor, the facts in my favor, and the jury in my favor. I thought it was in the best interest of the county for us to get this child some help. Let's get this thing off the table as cheap as we can, cheaper than it may cost me to litigate, and I made that decision. The merits are something else completely different that the state had already dealt with that I could use as proof. But I didn't go there because it would cost me more to do that and expose a greater risk to the taxpayer, many times more than what I had to settle the case. If we lost one thing, the attorney fees could be 4 to 5 times what the case may have been settled. So I made that decision as a business decision for the taxpayer. And that is not, what I'm trying to get y'all to understand, that is not to be articulated into an assumption of any guilt or any activity. It was a business decision and a decision in the best interest of what I felt for the law director's office and that child. Because I know what it takes to defend the case. And it was better to go the way we went than to go down the path of litigation on all the parties concerned, and especially Knox County. The facts are the state investigated. They reinstated licenses. They did not indict. They found nothing relevant to proceed. It came back to Knox County. And Knox County dealt with local policies and local issues on anything beyond that. That's all I know. And that's what I was trying to say to you all, because this case was mentioned in the resolution, like it or not. And the inference was trying to be made that this case proved guilt, like it or not. And I'm saying that is not the case. This case did not prove guilt. This case did not go forward for anything related to Miss Gill, Superintendent Thomas, or Principal of Southfield. This case did not go forward because it was in the best interest of the child. It was in the best interest of Knox County. It's in the best interest of the taxpayer. That's why this case didn't go forward. It was not to protect anybody. It was a financial decision and a decision what I felt was in the best interest of that special ed student not to have to go through a litigation process. I made that decision, and that's the way that decision stands. It has nothing to do with what you're talking about here. That's all I'm saying. Whether she's effective or ineffective in this committee has nothing to do with this case, and this case shouldn't be inferred upon her effectiveness with a committee or not a committee, or how people feel about her, or like her, or don't like her. You could say the same thing about the other people named. There may have been a reason I got out because of that. You don't know, and I'm not privileged to tell you. I'm doing my best to communicate to you what this case was about. Now, your issues as it relates to effectiveness and good cause, it is an excuse for failing to perform a required act by law. That's what good cause is. So you have to determine, based upon the totality of the circumstances, if good cause exists and what's being discussed. That's what I'm advising you now. And that's all I'm advising you. So you have to weigh the facts to determine whether or not there is a legal excuse for failing to perform a required act by law. And that is up to you all. That's a policy thing. It's not a law director thing. So when it relates to me settling a case, it does not condemn anyone. It doesn't prove anything against anyone. And you can't infer that to be true. I've tried to make it clear to you. I'm trying to make it clear to the taxpayer. I made that decision, and I made that decision based upon two things. Economics for the taxpayers in Knox County, and the best benefit to that child, period. The facts were in my favor. The law was in my favor. But should you go forward, sometimes you shouldn't just go forward to be going forward. It's not the right thing to do. And by George, I decided not to do it. And that's why I decided not to do it. I can't make it any more clear than that. The law was in my favor, and I believe it. The facts were in my favor, and I believe it. But sometimes it's not in the best interest of all concerned to go ahead and fight the fight just for principle. So that's the decision that was made. Now, you all are talking about something different. But what my issue, even talking about this, is that you was referred to this case as a foundation, whereas, and it shouldn't be in the whereases. But that's where we find ourselves, and you all have to, you all need to deal with this as the facts before you and make a decision whether there's good cause to remove somebody from the committee. If there is, it is. If there's not, there's not. But don't use this case to do it with, because it does not meet the standard of good cause. That's all I'm trying to tell you. I'm giving you that one.